Good afternoon, everyone. Thank you for joining us today for another installment of Exploring Our World, our series here at Colonial Williamsburg, where we talk about the lives of people who lived in the 18th century. Throughout the month of March, we've been discussing the lives of women here in Williamsburg and really across this area in honor of Women's History Month. Now, I am Christopher Hennessy, a historic interpreter here at Colonial Williamsburg and a recent graduate at William & Mary Law School. And with me today are Ann Corbett and Nicole Brown. Thank you so much for speaking with us about the rights and privileges of women in the 18th century. Now, as an easy question to get started with, could you please introduce yourselves?
Good afternoon. My name is Ann Corbett. I'm a historical interpreter here at Colonial Williamsburg for the last 5 years. When you come to town, you may find me giving tours of buildings or standing on the streets or even leading groups of children through the town.
And as Chris said, my name is Nicole Brown. I've worked for the Colonial Williamsburg Foundation for the past 7 years. Usually, you'll find me interpreting Ann Wager, who was the first and only teacher at the Bray School, which was a school here in the 18th century for enslaved and free Black children. But I'm also a part-time graduate student at William & Mary in the American Studies Department, and I helped co-develop the Women in Law tour that you sometimes see during Women's History Month at the Capitol building.
Right, thank you. So the key part of this program is audience participation, and we are looking forward to answering your questions. So go ahead and start posting your questions in the comments. Now, before we begin, one last note. We intend to have an open and candid conversation today about these topics of women in the law. As such, it may include sexual assault, death, racial inequities, and children born to unmarried parents. These are all sensitive topics that may be challenging for some viewers, so please be advised, but we're going to chat through them. So, to get started, what are rights? How do they differ from privileges? And what are privileges as well?
Do you want to go first?
Yeah, sure. So, rights and privileges. One of the most common things we find when folks visit us here in the 18th century is that folks believe that women are excluded from both of these things, rights and privileges. And in fact, they have access to rights here in the 18th century, as rights are something that is guaranteed to you by law. Now, a privilege can be something that is classified. Something such as voting here in the 18th century is a privilege. The ability to vote here in the 18th century means that you must meet a specific set of requirements in order to vote. So to vote in the 18th century, you must be male, 21, white, free, landowning, and a Protestant Christian. So
the interesting thing with rights and privileges is while they're a universal concept, how we define them is malleable in some ways, because depending on the society that you're living in, that interplay between societal expectations and the law is certainly apparent. And so how 18th century Virginians, colonial Anglo-Virginians, are defining rights and privileges is very much like Anne stated. A right is something that you cannot have inherently taken away from you, and those are protected in the 18th century for English men and women under the English Bill of Rights, which was written in 1689. That being said, a privilege is based more on your demographic. It can be based on sex, as well as class, race, and certainly sometimes even location. But when we're looking at women, and women within the law, it's also really important to understand that women are not a monolith. And so while we were just referring to rights and privileges, we were specifically defining free white English women within those laws. There are other laws that completely negate 52% of the population here, which was Black, the majority enslaved, to having any sort of rights within the parameters of Black slave code laws as well. That's not to say that free Black women don't have rights or that they don't execute them within a legal court of law, or enslaved women, but they're not represented in the same way through the legal system and its defining of rights and privileges as white women. And the same would apply, of course, for Native women or Native American women.
So that is actually a very good transition to a good, you mentioned slave codes and laws associated to that. Could you go into that a little bit more? Both the development of slave codes broadly, as well as specifically how they apply to not only enslaved women, but also free women of color.
Sure. Do you want to go first, Anne, or do you want to go?
go ahead.
Okay. So when you look at Black slave code laws, they really are established very early on, or they're starting to be established very early on in the 17th century, and then are added onto over time. With the individual that I portray and the graduate research that I'm doing, the best way I've come to understand slave code laws is that they're often not proactive but reactive in response to enslaved and free Black communities, either fighting against, speaking against, or resisting in a myriad of forms the system of oppression that a legal system may place upon them. So in some ways, the Black slave code laws that you see here throughout the 17th, 18th, and then of course into the 19th century, in some ways also manifest the agency or the resistance of Black communities, and then the legal system and the dominant white population continuing to place restrictions upon them. So one of the ways in which I think that's most apparent, at least to me, is the rights that Black women have to access of their children. So starting in 1662, there was a slave code law called or defined the status of the mother law, which essentially meant that if a woman was enslaved, all of her children would be enslaved. Their status was based on the mother, not the father. And what that meant is that as those children were enslaved, they saw themselves, of course, as people, but the law did not. And so those women didn't have the same ability to legally protect their children as a free Black woman, or certainly a free white English woman would have.
Absolutely.
So that's just one example of that genesis, because actually that law came about because in the middle of the 17th century, a free or an enslaved woman with a white father petitioned the court for her freedom, and actually the laws responded to Elizabeth Key and her petition for her freedom by creating that law. So that's really, you see that time and time again throughout the 18th century with slave code laws and women's interactions with them.
Absolutely.
So that touches a little bit on some of the demographic differences between how women interact with the law. Can you think of any other demographic differences as well as to how this gets introduced? Be it single, be married, economic course, or really as broadly defined as possible, anything you can think of.
Yeah.
Well, starting with the condition of a woman's in marital status. We are going to be classified in different ways depending on if we're married or unmarried women in the eyes of the law. In the eyes of the law, if we are unmarried, whether that be widowhood or just have yet to marry, we would be femme soles and in control of our legal rights, our own property if we should own some. Once we marry, we are going to be considered femme couvert, or as the term is used to describe a condition of being covered by the protections of your husband. Your legal rights are still there. Your husband is just exercising and protecting those rights through that union. It's part of the contract of marriage as it is.
Right.
And the other side, there's one more variation to being looked at by the eyes of the law, and it's very loose in the 18th century depending on the geographic location. For example, if you were living in the metropolis in London in England versus the rural area of England, versus living over here even in Virginia, there's a concept that's accepted as being femme sole trader, a woman who's going to continue to manage and exercise the access to her own property and her own rights throughout her marriage. And this is really going to affect how women are existing in the 18th century.
Right. And of course, in this situation, we're talking about free white English women.
Of course.
Black women, again, under slave code laws, enslaved individuals are not allowed by law to marry. That being said, you do see individuals like Edith Cumbo, Elizabeth de Rosario, just to name a few of the free Black women who lived here in the 18th century in Williamsburg, who do maintain their own households. But of course, in the case of Elizabeth de Rosario, her marriage to an enslaved man is not recognized by the court of law. And so the dynamic in that household is, of course, different than when we're talking about femme sole or femme couvert, which are terms that are defined under Blackstone's laws, the very common set of 18th century laws that are used by those here in Virginia and England. It's again that dynamic of who is married, how do you identify marriage, that interplay is certainly present.
And even within the 18th century, we will see the community, the Virginians themselves, choose to acknowledge the condition of a woman in marriage in different ways from the early period of the 1700s when Mary Greenfield wants to have her rights restored after her husband has abandoned her, left her in a marital state with no legal access to property that could sustain her throughout her later years in life. The Virginia Assembly at the time, the General Assembly, will deny her petition for those rights restored, but within 30 years, they're listening to Frances Greenhill with the same story, and they are listening with a more sympathetic ear, and followed even further with Susanna Cooper, who is also going to be petitioning the legislature for help for redresses to her issues, and just a simple acknowledgement that they want to have access to their property so that they're not a burden to their communities, and their communities are supporting them in this.
Right, and so that's a great point of looking at that first case you referenced, which is from about 1700, the second case from about 1730, the third about 1750. You can see over the course of 50 years how someone's marital status as a free white English woman and what they can have done within the courts, there's an interplay back and forth, and it's very dynamic.
Very.
So that is an excellent lead-in. We have a question from Christian, who says that they hear that some women can marry and retain their rights using some special techniques. So based on that point, can you go a little bit more into sort of coverture, but I'm certain you define coverture, but then how a femme covert could operate under that as a sort of, not just retain rights, but also move within that system?
Right. So, and you bring up a very good point, Christian, which is that you have femme covert, which as we defined it is you're covered under your husband, you still have rights under the English Bill of Rights, but you cease to exist as a separate legal entity, broadly speaking.
Broadly.
And femme sole, which is as an adult woman who's either widowed or, above the age of 18, you represent yourself individually. But within that, there is a lot of exchange that you can have prior to your marriage as well as during your marriage to retain property rights. And part of that comes into the idea of dowry and dower, right?
Dowry and dower.
Right. So dowry, to put it simply, is what you put into a marriage as a woman. Dower is what you get out of it at the end of a marriage, to put it frankly. So a woman may bring in enslaved individuals to a dowry. She may bring in land. She may bring in other real property. Right, exactly. But if there is a pre-marriage contract, sometimes it's also defined as a jointure settlement, although those two things are slightly different.
Slightly.
You can negotiate to, in some cases, have your dowry protected in a trust separately from your husband, or have law written that your property that you're bringing into a marriage goes directly to your children. There are lots of ways through jointure settlements and pre-marriage contracts to control your property, and often this is seen amongst, especially in the middle of the 18th century, elite wealthy families.
Yes.
I feel, Linda Sturtz talks about this in her book. There's a great book called Within Her Power, Propertied Women in Tidewater, Virginia, in which she says that the Virginia fear is less the wicked stepmother, because marriages and remarriages are happening all the time, and more the greedy son-in-law. And so fathers and uncles will, if not the woman herself, which does happen in some cases, negotiate for these settlements to make sure that a man is not then leaving his wife destitute.
This was a connection to tying the real property of the bound property. To the land that the woman is bringing in with her dowry, so as the greedy son-in-law couldn't just dispose of the real property. That was a key indicator in their understandings.
Right. And when we're talking about property for elite white women, or white women in general, you do see other individuals in Williamsburg know how to manage dowry and dower and what they're bringing in and getting out. Of course, we also have to reference that some of that property that's being defined as property is, of course, enslaved individuals and enslaved women and children.
So you have discussions of property, you have discussions of all sorts of illegal tools and instruments which women use in order to interact with society. Could you go into a little bit about sort of how individual interaction with the law may look different depending on what court you're in? Because there are thousands of courts that they can go to.
Sure. Yeah. So when you're thinking about the courts here in Virginia, we specifically have county level courts, we have our general court here in Virginia, and then within these court structures, we have different variations on the courts that are being held there.
Right.
From terminal courts or courts that are deciding whether someone's violated a criminal act, held in the county courts, which are generally, they're generally around the enslaved individuals who are being tried for crimes. And
Right.
how these individuals are going to interact with their court system is going to vary greatly from how somebody who's not in that condition of enslavement.
Yeah.
And that's the real connector. Being in the condition of enslavement is going to limit, as you know, many of your access to the legal rights that a free individual would. And free individuals are going to be including people like servants, as well as even transported convicts are going to
Yeah.
have more legal access to rights than an enslaved person,
Yeah.
such as Catherine Peppers and Harry, who are in Bedford County. Catherine Peppers is a free woman. She's a servant. Harry is the enslaved man. Their trial begins in the same county court on the same day. His is going to be completed that day, where hers was only going to go through the grand jury process.
Right. So there are different tiers of courts. You have your county court that deals really with your day-to-day civil cases under 20 pounds, or predominantly enslaved individuals of criminal cases. When you're dealing, though, with the general court is criminal cases for white individuals usually, although we have seen a few enslaved women, Mary Aggie in particular, whose case was handled through the general court. But you're dealing with, under English common law, cases of a criminal nature for white individuals or civil cases above 20 pounds. In addition to that, you also have equity court. Equity court is, if you're familiar with Charles Dickens, you know, when he talks about all his court cases in his books, and they take 20 and 30 years, and they take so long, and they're all about money. Often that's actually really what equity court is. If you feel you cannot, through the English common law system, which would be county court and the general court, get an equitable response, you can go to equity court. You also have things like orphans court for boys and girls under the age of 14. You have the hustings court, which is the city court of Williamsburg. So lots of different courts women can interact with. But most often I find black, white, free, enslaved, and in some cases native, they're interacting most commonly with the county court.
County courts.
On a day-to-day basis.
Their marriages will begin there.
Yes.
If they want to be business owners, they will have to interact with that county court.
Right. Or if you're somebody like Elizabeth Hay, who lived here in Williamsburg in the 18th century, you are showing your adroit ability to manipulate dowry and dower through a county court. So in 1773, her husband, Peter Hay, passed away. In fact, their house is still on the Duke of Gloucester Street. And when Peter Hay passes away, he leaves his wife, Elizabeth, everything. She rejects the will because she knows that if she accepts the will and accepts everything he has to offer, and he's massively in debt, that his creditors can get to the estate before she can. So she says, I reject the will in favor of a widow's third. Because the widow's third is protected before any creditors can attack the rest of the estate. And so Elizabeth actually gets her widow's third, and then the other 2/3 go to the creditors. But that's just one example of how women are interacting in the county courts on a day-to-day basis. They know what they're doing. They know how to ask for what they want. Free, enslaved, black, white, or native.
The widow's third is such an important concept in the marriage for a woman and a man and their property. Many folks will be leery of trying to trade and deal with the man and buying his land without that confirmation that the wife has agreed to the sale,
Right.
out of fear that she could come and claim in future times her widow's third of that land. So it's an integral part in why women are being asked to sell land before the county court. So why they're being examined privately and making their confirmation that the sales are going to go through.
Right. So while there are many different courts that women interact with, what I've seen most frequently in my research are the county courts are really, really a place where women are participating in very different ways.
So shifting gears a little bit, but still keeping on this topic of status, we've had a couple questions about female indentured servants in particular.
Okay.
So let's start with first off, before we launch into guest questions, sort of, could you talk a little bit, give a little bit of background of what an indentured servant actually is, status-wise, and then after that quick definition, I do have a couple questions for that specifically.
Okay.
An indentured servant is somebody working on a contract. This is not somebody who is owned. They're not property. They are free individuals who are being bound by a legal contract, something that they and the master have both agreed on.
And that's whether it is an indenture that was agreed to in this contract basis by the individual to the master, or a criminal indenture that is still a legally binding document.
Legally binding documents, yes,
right.
Indeed. So as women indentured servants, definitely are going to be exposed to a little bit different level of scrutiny, simply for their control, their agency and their existence and how they live their lives are going to be much more tightly controlled. Marriages, children, and all of this is going to be legislated and controlled by our laws.
And a couple of cases I can think of that really speak to this are very often when you're looking at cases of bastardy. And please know when we're using that word, it is a legal 18th century term that we are utilizing. It's not a term I, Nicole, would use in the 21st century. But in the 18th century...
it actually happens to be the third most commonly tried crime in our county courts in the 18th century.
It really is. And a lot of times you see it across lots of different demographics, but in particular, indentured women are not by their contracts traditionally allowed or supposed to be having children while they are indentured, and may be put in situations, compromising situations, where they end up in the court of law where they may not have had consent in a situation, or whether they did or did not, are now being put through this legal loophole where additional time is being added to an indenture because they had a child out of wedlock.
And the future of their child is not 100% certain based on who they are and who that child is.
Right. But the interesting thing, too, is when we go back to slave code laws, right, and marriages, and that any enslaved individual cannot by law be married, you do see some white indentured women in Williamsburg. Specifically, I'm thinking of Matthew Ashby's mother, who Matthew Ashby was a child of mixed race. He had a white mother and a white indentured mother and a black enslaved father. And when he was born, Virginia law at that time had been modified, but initially they didn't know what to do with mixed race children. Are they enslaved? Are they free? The status is based on the mother. So Matthew Ashby is actually indentured for 30 years to the church as his punishment for being born, and his mother, I believe her indenture is added onto. So really, indentured women do have rights within the law because of these contracts, but they still are susceptible to other systems of abuse, but it is not the same as enslavement.
Building on a little bit of sort of what you were saying previously with some of Matthew Ashby's experience, but Brian and Linda ask, in general, what would happen to the children born by a female indentured servant? And I know it depends on time periods, let's say toward the end of the 18th century.
So towards the end of the 18th century, depending on the race of that child, it's really going to depend on what happens to that child. So an indentured servant, a white woman who is having a child while she's an indentured, her child is going to be an indentured. That's the end story. How long the child is indentured is going to depend on who the child's parents are. If they're both white, we're talking both Anglican indentures or whatever, we are talking about a child who's probably going to get 21 years of an indentured. 21 to 24 years. But once you reach to the mixed race status, then you are talking 30 years.
At least 30 years.
At least 30 years.
It also depends on whether or not the father claims the child.
This is the other catch. Who's the father? Is the father somebody who's willing to step forward and say, I am the father, I claim the child, and thus I'm willing to take care of the child? They are probably going to pay the fine involved in this child being born, which would eliminate a lot of the issues with indentured contracts for these children.
So their
However,
indenture
that's
can be
not
removed.
likely always the case. The majority of these women are seeing their children indentured as well.
That's a really good point, because usually if the father acknowledges it and pays the fee, the indenture is done.
As we say in law, we want your money way more than we want anything else. So if there's a way for you to pay off a fee and a fine for your infraction, we're offering you that first. However, these are extremely costly fines, upwards of 10 pounds. And that's half a year's of the average person's wage.
Yeah, exactly. So it depends, like you said, very much on the race of the child and the status of the parents.
Status of the parents.
Yeah.
Also as well, we have a question from Christine, and just as a warning, this question may be traumatic for some viewers, so check back again in a couple minutes, but just that warning there. Christine asked sort of what options did indentured women have if they were treated badly, let's say regular assault or ill treatment in general, or even sexual assault. So what options do they have before the law, essentially?
Sure.
Well, there are violations of contracts that we are speaking of, but with any violation of any contract, it's going to come with the burden of proof. So if there's enough proof, if there's enough witnesses to any sort of abuse, the woman may have a claim to be able to bring before the county courts or before a justice of the peace in her local county to bring forth this issue to address the grievances. Right. And if she's heard and if that is agreed upon and accepted that she is being abused, then there is going to be a possibility for her to have another master.
Right.
But there's a lot of caveats to this. Who is the owner?
Yep.
Who is she?
How is she going to be scrutinized?
How is she going to be scrutinized throughout this process? So there's what's available through the law, and then there's probably what we would see happen.
Right.
And how easy it is to access some redress of grievances in the law is going to be difficult for many of those indentures.
Yeah, and I think in addition to that, this in some ways solidifies one of the biggest differences between indentured women and enslaved women, is that while it is extremely difficult for indentured women to find legal recourse, there still is the option of legal recourse because it's a contract. With enslaved women, if they're assaulted, there is no legal recourse.
As a follow-up question as well, you mentioned sort of legal recourse for sexual assault for an indentured servant. What about the same thing for married women?
That's very different.
Yeah. There is a marriage contract. There are marriage responsibilities. So while in theory the king does not want you harming any of his people, again, there's a huge burden of proof. It's not to say that a woman who, with a valid claim, couldn't get a separation of bed and board and be legally separated from a man who is considered a violent individual. But it's not always as common as one would like to think. And it's, again, going to be a matter of status. The higher status you are, the easier access you're going to have to some of these redresses.
So what it actually makes me think of is the Blair v. Blair case.
It does.
So Kitty Blair, occurred in 1772. Kitty Blair sues the court to divorce her husband, John Blair Sr. It's extremely controversial because John Blair Sr. is one of the wealthiest people in all of Virginia, and sets kind of a precedent for how divorce may later be dealt with. Because, like you brought up, there are two forms of separation in the 18th century for English white women. Divorce mensa thoro, which is separation of bed and board, and divorce a vinculo a matrimoniae, which essentially means annulment.
Yeah.
She's looking for annulment because she says the marriage has never been consummated. But how she is treated, she's scrutinized heavily, but the access that she has to well-paid lawyers, including Thomas Jefferson, who served as one of her legal advisors, is very different than a poor married white woman in a rural county, right? So what I've noticed traditionally throughout looking at the York County Records Project is it seems that claims of assault from married women are sometimes taken more seriously, but often the race of that individual as well as their status heavily plays into whether or not they can get a separation or if the court is going to acknowledge that.
So, drawing back a little bit to modern perceptions of women's access to the law in the 18th century and those privileges. Our modern understanding culturally is often based on how we view the Victorian era through the Edwardian through even 20s, 30s, 50s.
Yeah.
So let's talk a little bit about that somewhat. We have a question from Brandon, for example, discussing did unmarried women have the privilege to attend parties or only attend parties unattended or only wear certain clothing option, like clothing colors. They specifically are thinking of Bette Davis in the movie Jezebel when she wore a red dress. So talk about sort of pop culture ideas of this
I'd
and how
love to
they
talk
might
about
differ.
this. So our perception of what women could or could not do in the 18th century, how they dressed, how they interacted, is definitely clouded by some of our perceptions of the Victorian era. I think this is a great example. Women definitely attended parties, especially in the capital city, all the time. There was no limitation on what they could or could not wear. Indeed, there's a great, great book about women and their political reflections in clothing that was published very recently that actually talked about the fact that upper class men and women were irritated often throughout Anglo-America that lower and middle class women were wearing these beautiful clothes because they couldn't separate whose status was what anymore. And that's not only applicable to white women, but definitely to enslaved women.
Absolutely.
I would encourage you, we have a program called What She Had On Before She Went Away, which focuses on runaway ads that have been researched by my colleagues Deirdre Joan and Hope Wright, that focus on enslaved women and their clothing. And what that meant to those individuals and their identity. And clothing is really one of the ways that, whether manipulated through the legal system or not, or manipulating the legal system or not, women sometimes show their agency, I think, in really profound ways.
I think one of the things that shocked me the most when I first started working here a few years back was this idea of women in their clothing in the 18th century.
Yeah.
And I was just as guilty as many other folks with that Victorian lens, and then
Yeah, me too.
realizing that it was a lot more risque than I had ever given it credit to being. And of course, that's all depending on where you're at in the world in the 18th century.
Sure.
The higher up you are getting to the kings, the queens, and the courtly classes, maybe the less clothing you might see on some of these ladies than you may see in the working class. But the idea is definitely there that women are probably a lot more sexually free than we give them credit for
And some of
in this time period.
Yeah, and some of that is clouded by this Victorian perception, but some of it's clouded by our own perceptions too and biases of like what is appropriate in terms of clothing. There's a great blog that was done by one of our former milliners named Abby Cox about, well, cleavage. And in the 18th century, it's not a big deal. That's why they have these things called tuckers, which literally are ruffles right around the neckline. Wearing something like a modesty cloth, that's not an 18th century concept. And if you look at portraiture, fashion plates, inventories, women's clothing is filled with bright and vibrant colors. So what women could or could not do when attending a party or when going back to what they could or could not wear, in fact, it's very often not defined by the law. One of the few things that doesn't usually come into play.
Yeah.
So let's say a husband dies and he has debt and the wife now needs to manage the estate. Very rarely do you ever see her clothing being negotiated to manage debt. That's like, it's hers and it's not to be touched. There's only one example I have ever seen in a county court where women's estate had to do with her clothing, and it was because she died very young at 24.
On sort of similar ideas of misperceptions from the past, Bernie asks, is there any evidence of women holding positions of power despite the norms? And take position of power broadly, both what we think of as the hard political power, but also a lot of the stuff that happens, quote unquote, behind the scenes or in society, so to speak.
So I think that's an interesting question, because what kind of power, like you said?
Yeah.
Because I believe women have always wielded a certain power, whether we hold political offices or whether we are running businesses. Women have always, in essence, been considered part of the voice of the household, which is one of the reasons we weren't given that voice to vote. It was considered we would just be voting as a household. And in that respect, women are probably very often encouraging their husbands in certain lines of thoughts and voicing their opinions in the ways that women have always done so.
Yeah, I think it also begs the question, what are the norms that we're discussing? But the best example I can come up with, because it's what I've recently been studying, are looking at the Black communities in Williamsburg and their massive, massive influence on Black children's education. So Anne Wager, I mentioned, is the person I portray. She was Anglican, a member of the Church of England, teaching at a school for enslaved and free Black children. But I think there's often a misconception that she was the only person teaching enslaved or free Black children. And when you look at the oral histories of the community of First Baptist, the oral histories of individuals throughout Williamsburg, as well as reading through, a historian named Marissa Fuentes has this great phrase called reading through the bias grain. If you take a document and you pull it almost like a piece of fabric to look through the diagonal, you can see things you wouldn't see if you just looked at it along the grain. And if you do that with some documents in relation to the Bray School, you see that there are enslaved and free Black mothers who are educating their children in spite of what this pro-slavery ideology is being placed upon these children. Or the children themselves. Hannah is a great example. Hannah was an enslaved girl who attended the Bray School in 1762, and in 1765, her slave owner complains that she is not following the pro-slavery ideology he wants her to follow at this school. She is resisting. She is finding power and agency, and I think that's one of probably thousands of examples we could pull for women time and time again, Black, white, free, and enslaved, Native American, tributary, or sovereign nation finding systems of agency.
Speaking of not necessarily having a direct influence by holding office, but Mary Aggie's influence is going to ripple an effect for all of Virginians, and it's one of the most unique examples of an enslaved woman having a positive effect for a multitude of individuals beyond those of her own. Mary Aggie's story is very simple. Mary Aggie is an enslaved woman. She is living in York County. She is Christian, she's baptized, she's believing in her faith, and she begs for her freedom from the council and the governor. Governor Gooch and the council are going to deny her freedom based on her claim of being a Christian.
Yeah.
Because unfortunately, we've already written this in slave code that's clearly defined in the 1600s that baptizing a slave is not making them free.
Right, and this case happens in around the 1720s, 1730s in Williamsburg.
And so when we see her come before the York County courts and we see her being brought before a charge with a criminal action, the governor is paying attention, the governor is following along, and he is going to insist that she's brought before him yet again so that she could plead through some mercy on her own behalf. We call this benefit of clergy. It's an act that allowed for free white men to be branded on the hand and to be given one opportunity to be spared a death sentence for your crime.
And this is in cases of theft.
This is in cases of theft or manslaughter or mayhem as well. So we have a list of things that are clergyable. The problem is, by the time Mary Aggie wants this benefit, the only people legally allowed to have this are men, white men. And so she's doing her Aggie thing, as I say. She is standing there and she is pleading with these people based on her own beliefs. And it had to have been effective because out of the 12 members of that council, at least 12 Virginians who are going to make a decision, 6 say yes and 6 say no.
Right.
To split the council down the road was pretty amazing. And of course, the end result is Mary Aggie is going to her presence is going to push along legislative change.
Yeah.
The governor's reaction to this is very simple. He can't solve Mary Aggie's problem. Unfortunately, the only conclusion they could come up with was a pardon and sending her out of the colony.
Yeah, which if they wanted to send her to the Sugar Islands, which is essentially a death sentence.
Yes, so there's a bad end for Mary Aggie, but Mary Aggie isn't going to be done with us even after they
No.
make her leave us. Her legacy lived on many, many years afterwards.
Right. So because Mary Aggie pleaded for benefit of clergy, they didn't know what to do in a county court, so they brought her to the general court. They didn't know what to do. They literally changed the law so that benefit of clergy can apply to women. And if you look at Terry Snyder's Brabbling Women, it's a great book. That case likely saved Mary Aggie petitioning for benefit of clergy, likely saved close to 300 women's lives.
Oh, yes.
In Virginia in the 18th century.
So you touched on this sort of throughout, and our discussion primarily was working through the idea of women interacting with the court system, but a key part of the law is the legislature.
Yeah.
So how do they interact with the legislature?
You know, free white English women under the English Bill of Rights, which we've mentioned is written in 1689 and is how rights are protected for English subjects, they do have the right to petition their government. You see occasionally women doing this, like Frances Greenhill, who you've mentioned, and Susanna Sanders Cooper, who were essentially petitioning the legislature to have a special bill written so that they could have an estate separate from their husbands. So free white English women do have the right to representation and the right to petition their government. And you do see women within the county courts and sometimes the general court reaching out to their representatives and saying, I have a problem and you need to push this bill forward. But again, very much race as well as class and status, what's your last name effectively in Virginia, influence their involvement in the legislature, right?
Yes. Yeah, especially with Frances and Susanna. Their cases are very interesting in the simple case that Virginians, by the time Frances and Susanna are petitioning for their legal rights to be restored, Virginians are starting to separate how they're dealing with property rights and women as opposed to how England is dealing with property rights and women.
Yeah, and how women are going to interact with the legislature in regards to their property rights.
So the legislatures were very pro these women, their property rights being restored, but it really solidifies the fact that legislature here in Virginia is only one point of the whole legislature. There's more to the process of getting a bill written here in Virginia in our colonial period, and even if the Virginia legislature was pro these women, they still had to conquer the imperial side of this.
Yeah.
And they would be dependent upon the king's signatures to make their bills laws, to grant them the access to the rights that they had. In both of these cases, both of these women are bringing in over almost 1,000 acres of land to their...
It's a sizable amount of property.
It's a sizable amount of land. I believe Frances brought in almost 200 pounds of real property.
Yeah.
These women were being described as women of character, and the men are of no consequence. So they're definitely utilizing everything in their disposal, and the men here are definitely utilizing, if nothing else, these women's cases as an opportunity to continue pushing the idea of who's really legislating for Virginians.
Right.
Are Virginians being legislated by those who we elect? Are we completely reliant upon what's being crafted in England? And do our values and our specific circumstances of our statuses, the way we are developing the rules of inheritance, they're definitely varying and pushing us into a different boundary than England.
I think another way that women interact with the legislature, and it goes back to your topic before of hidden agency amongst women. These gentlemen who are members of the House of Burgesses or the Governor's Council are married to very powerful women who sit at the heads of their dinner tables. Because in the 18th century, the woman sits at the head, the husband at the foot. And are presiding over elite intellectual conversations at dinner. So I think likely, if you were to look, you'd see also that these wives may have impacted implicitly portions of the legislature.
All right, final question. If you could pick one thing, and yes, only one, what is it that you want every visitor who comes to Colonial Williamsburg to leave understanding about women's history and their ability to exercise rights in colonial Virginia?
Well, to start with, women have always been here.
I think that's such a good point, though.
We arrived in mass in 1619. to begin, quote unquote, the families of Virginia.
As
And
did in, African
as
women
did
as well.
Africans
Yeah.
as well. And that year is really going to be not just the year of women, it's the year of the Africans, it's the year of change for Virginia. And we will have had an active role, whether it's within power, of seats of power, or whether it's
Yeah.
behind the scenes. Women have always had an active role in shaping and pushing forward Virginia.
Yeah, and I think in tandem with that, we're sitting on indigenous land. I mean, this land was owned by the Powhatans before it became Middle Plantation or it became Williamsburg, and women within those communities also had their own legislative standards and interactions too. But I think above all, what I'd want a guest to walk away with, or anybody, is that law and women's relationship to law is not static. In the same way that you wouldn't look at something from 2021 that's happening currently in the Supreme Court and assume that what happened in 1930 is identical to what's going on. You wouldn't say that all the laws on women in the 1930s are the same as in 2021, likely. Then the same should be looked at with women in the 18th century. They impact the law, they are impacted by the law, it is a dynamic relationship, and in understanding it, you understand Williamsburg in a much more comprehensive way.
All right, with that, that is all the time we have for today. I want to thank Anne and Nicole for speaking with us. We're also grateful for you for joining in our conversation and sending us those great questions. Now, I want to take a minute. This program was made possible by a generous grant from from Ferguson Enterprises, and we thank them and all of our donors for that support. It's only because of you that we can share the complete and engaging story of our nation. We're so glad you took the time to visit with us today, and we hope you'll visit us in person soon here at Williamsburg. Have a wonderful rest of your day.